Okay, thank you very much. I have to admit, I'm just about to make a big mistake, because there's one very important rule for any conference: don't talk politics. And I'm just now about to talk about a very political, highly political issue. And I have to beg for your pardon, because this is going to be somehow emotional, because being from Europe, I'm directly affected by the Brexit. So I try to be objective as I can. I'm very happy that nobody has walked into this room waving a Union Jack, because that might have caused some conflicts. So now let's start talking about the Brexit. Of course, everybody knows in principle what the Brexit is. Basically, it's quite easy. The United Kingdom held a referendum about if they wanted to stay as a member of the European Union, yes or no. This referendum was held on June 23, 2016, and there was a leave, 52 to 48 in favor of leaving. Why ever? I'm not going to discuss that. Basically, this is the territory of the European Union as it is today. So all these nice green countries, green-colored countries, are the present EU member states. And on the right side here, you see what's going to happen very soon, because the red-orange spot on the map is going to be no longer part of the European Union. So, following this vote, the United Kingdom declared under Article 50 of the European Union Treaty on March 29, 2017, that's an important date, that it has the intention to quit the European Union. And based on Article 50, that means that there is going to be a 2-year transition period, and the leaving country and the remaining countries, or the European Union, they were supposed to find within this 2-year transition period a solution. How the UK would actually leave the European Union, and more importantly, what would actually be the rules to be applied for the mutual coexistence and the mutual dealings between these two parties following the leaving of the European Union. So the UK, for its own part, they started acting quite quickly and already passed the so-called European Union Withdrawal Act, which basically says that for the start, they are going to more or less transfer all EU laws into UK laws, because otherwise they would not have many laws left, because most of the UK laws nowadays are based on European Union law. There was a second, more important issue, and that was this agreement which needed to be actually negotiated between the European Union and the UK regarding the effect of the withdrawal. And this is the so-called agreement on the withdrawal. So what's going to be, just from an abstract point of view and not referring directly to IP, what's going to be the effect of Brexit? First of all, of course, United Kingdom will withdraw from the European Union. And that means that European Union law will not longer be applicable. None of the European laws which now apply in the UK will longer be applicable. Also, the European Court of Justice will no longer be competent to rule on issues concerning the UK. And actually, that was one of the crucial issues. The UK did not longer want to accept the supremacy of the ECJ. Also, the United Kingdom will withdraw from all EU institutions, European Commission, European Parliament, all these institutions, the British will withdraw. And as a consequence, the United Kingdom will be a completely independent, autonomous state without any multilateral or bilateral agreements with the EU or EU member states. And that is important. There will be all the agreements, and these are virtually tens of thousands of agreements, between the countries, between the EU and each country, they will all be gone on one certain date. And as long as there will be no new agreements, that basically means that the relationship between the United Kingdom and the European Union and its member states will be reduced to WTO standard. So that it's like, I don't know, Kenya or any other country which does not have a special agreement in place with the European Union, the UK will have the same status. At least this is the general legal framework. So what does this mean for IP issues? Once the withdrawal is completed, the UK will have left the system of European Union trademarks and also EU designs. And these are, in total count, 1.6 million IP rights, which at present are valid throughout the European Union. IP rights, European Union trademarks, and also European Union designs will no longer be valid in the United Kingdom. And vice versa, trademarks, UK trademarks, which right now are, for example, a potential basis for filing oppositions against EU trademarks, will no longer be suitable as a basis for opposition. There is also an effect on representation, which for the IP owners may not be so important. For our profession, of course, it's very important. It means that, obviously, EU IP professionals, lawyers, patent attorneys, trademark agents, can no longer act with effect in the UK. That's not a big problem because that didn't happen anyway. But UK IP professionals can no longer represent clients before the EU IPO. And for them, obviously, that's going to be a big issue. So now this is the overall framework. Now let's talk about the last 2 years, because that was this transition period, or the period which the parties have, according to Article 50, to negotiate their future relation. And basically that would have been the time to clarify all these issues and make sure that after the actual withdrawal, the parties could somehow coexist. So there have been extensive negotiations on an agreement on the withdrawal. But obviously, like in most agreements, the parties had different aims. The United Kingdom has said they want the best deal. That is what the government, right after the Brexit, promised to the voters. They said, we are going to get the best deal. So that means they said, okay, now there are some countries in Europe which are not member of the European Union, mainly Switzerland and Norway. So they have relationships with the EU without being members. And they have a nice life. They don't pay. Allegedly, they don't pay. Though they don't pay. Actually, they pay a lot to the European Union, but they don't have to be members. So, for example, they do not really have to accept ECJ case law judgments. So they said, we want to have a status better, or at least like Switzerland and Norway. So first of all, we want to have free access to the EU market. We want to have free trade. But we don't want to pay to the European Union. We do not want any influence of the European Union on the UK. We certainly do not want the supremacy of the ECJ. We want to have basically no freedom of movement of EU citizens into UK. That means the Polish worker, the Greek nurse, the German engineer, they are no longer supposed to have free access to the UK. And also we do not want European Union companies to do business in the UK, at least not without any restriction. That was the aim of the UK government. The EU obviously had different aims. They said, right from the beginning, a status like Switzerland or Norway can only happen if the UK, for the future, acknowledges some basic rules which apply not only to the European Union, but to the so-called European Economical Zone, which is encompassing Switzerland and Norway, which basically means that the parties must guarantee a free exchange of goods and services, freedom of movement, habitation, employment, and equal social security for everybody throughout the zone. They say also, if you want free access to the market, and if you do not want to pay customs duties, then obviously that must apply vice versa. And that also means that payments must be made to the European Union. There's also the requirement that whoever is member of this European Commercial Zone or Economical Zone must accept the supremacy of the European Court of Justice. And that all runs down to this nice sentence: they cannot eat the cake and have it at the same time. And it also means that the status of the United Kingdom following Brexit cannot be equal to the status of EU members, because that's the reason why you are inside the EU. You pay for it and then you get advantages. You cannot just get the advantages and not pay for it. So what's the present state of affairs? And now it gets complicated, because this is changing every day. And this is also the reason why I didn't count actually, but I probably amended and changed this presentation about 5 times through the last week, because things are changing so quickly. So basically everything looked fine, because after lots of hacking and bickering, the parties somehow agreed on a withdrawal agreement. So the UK government and the EU came up with a proposal for a withdrawal agreement, and the EU approved. The UK government couldn't approve because the Parliament in London had made a provision saying that the government cannot simply sign this withdrawal agreement on behalf of the UK without prior consent by Parliament. And that is where the fight started. Because 2 days ago, on January 15, no, that's 3 days ago actually, the UK Parliament, and you know this of course, has rejected the withdrawal agreement. 1 day later, the Parliament gave a vote of confidence to the Prime Minister, which basically means the government is still in place. And now nobody knows what's going to happen. Because the government says, we want to withdraw, and we need a withdrawal agreement. But there is no withdrawal agreement, and the one which is on the table cannot be signed. The EU says, we are not going to renegotiate this agreement. There's no way, because all the concessions which could be made have been made, so there is not going to be any renegotiation on the withdrawal agreement. There could be an attempt, actually, to delay the deadline for the final withdrawal of the UK. Basically, this deadline is fixed, March 29, because that is exactly 2 years after the declaration of withdrawal, of intention for withdrawal, was filed with the European Commission. So March 29, that's 45 working days from today, is the deadline, and that's when they are going to leave. The EU could agree to a delay of this deadline, but why should they do it? They said they are not going to renegotiate. So it's not going to be a delay because they want to renegotiate. They could say, okay, what about the UK reconsidering the withdrawal? What if they simply decide to remain because they find this is going to kill them? That could happen, but of course, in order to do that, there would have some process would have to start in the UK to reconsider the Brexit decision and maybe to vote for a Remain decision. This until now hasn't happened, and the government says this is not what we are not going to do. We do not want to have a second vote, and also they said we are not going to have new elections, which could mean that another party could be the governing party and they could decide. The funny thing is that today the majority of the voters in the UK very likely are against Brexit, but we don't know. Okay, so now we have, I believe, 3 different scenarios. Of course, there's hundreds of different scenarios. I try to just reduce this to the major. Number 1, the UK decides to remain as an EU member, the no Brexit scenario. This could only happen if the UK is holding new elections or at least a new vote on the Brexit. That cannot happen until March 29. That is, the EU, as I said, could delay the March 29 deadline, but only if the EU believes that as a consequence of some kind of consideration process in the UK will actually reconsider its decision. There is a big problem because end of May 2019 we will have European elections, and basically at that time the UK is not going to be a member of the EU any longer. So why, if we delay this deadline, they would have to vote for the European Parliament. They would have to send a commissioner to the European Commission. That's more or less impossible, and it would be ridiculous if 2 weeks later they exit. So that's not really a good chance that there will be a big delay. There could be a delay for maybe 4 weeks, but that's the absolute maximum. So nowadays, but that is my personal opinion, I believe it's being shared by many people in the EU, it's very unlikely that the UK will remain. Number 2. Second scenario, the UK might manage to renegotiate a withdrawal agreement, the so-called soft Brexit. This agreement would then have provisions on all issues, including IP issues. That's impossible, because the Parliament rejected the withdrawal agreement, and the EU has said, we are not going to renegotiate. So, to my opinion, this is not going to happen. Number 3, that is the most likely scenario, to my opinion. The UK withdraws from the European Union without any agreement. That's the so-called hard Brexit. Some people say it's the dirty Brexit. And to my opinion, this is by far the most likely scenario that we are going to see. So, to go into a little bit more detail, the unlikely scenario number 1, the no Brexit, that's easy. The ECJ has already decided that the UK may at any time unilaterally step back from the Brexit declaration, and that means they stay. It means nothing will change, because they will simply be an EU member. EU trademarks and designs will continue to be valid in the UK. UK trademarks will continue to be third parties' rights in the EU IPO proceedings, and UK practitioners will still be admitted for representation before the EU IPO. That's basically what I believe 90% of all the Europeans in the EU want. But as I said, it's very unlikely to happen. So this scenario can more or less be discounted. That would be the nice scenario. Everything stays green, the UK remains inside. So the impossible scenario number 2, the soft Brexit, that would have meant that there would be another 2-year transition phase, more or less 2 years, until December 31, 2020. During that time, nothing would have changed. And after that time, what would happen to IP is that the United Kingdom would basically convert, or they say they clone, all the IP rights which are now existing as EU-wide IP rights, trademarks and designs. They would clone them. They would create a set of 1.7 million new UK trademarks and designs. They would be granted automatically without even an application by the owners. They would be free of charge. The data for this would be provided by the EU IPO, so that would be easy. They could just simply create new trademarks. You wouldn't even have to do anything as a trademark owner. You would not even need local representation. At that time, maybe later, if you have to renew, if you have to, of course, if you have to litigate, if you have to go through oppositions, but basically the trademarks would be created, and they would have the same filing date, priority date, whatever, as the original EU trademark rights. So that would have been quite an easy process. And trademark owners, who would automatically be owners of an additional UK trademark, they could later decide if they abandon or whatever they would like to do. And of course, these newly created rights would coexist with existing UK rights. So that is a rule that we have applied in the EU for many years in cases where countries are joining the EU, because there you have the same problem. You have, let's say, trademarks in Croatia. They had and they need to somehow coexist with EU trademarks at the time when Croatia is joining the EU. And the same would happen with EU rights. So that would be relatively easy. But as I said, it's impossible, because there's not going to be a soft Brexit, because the UK Parliament has rejected the withdrawal agreement. So, but let's just stick with that unlikely scenario. What would you have to do? Let's assume in 2 weeks something happens, and still somehow we come to a soft Brexit scenario. What would you have to do? For the start, nothing, because we would still have this 2 years transition period. What you would have to do is you would have to make sure that that you are prepared to handle a double amount of trademarks, because now you have one EU trademark, and in 2 years' time you have a EU trademark and a UK trademark. So you have to somehow take care for administration. Because you probably don't want that to happen, because that would simply be too many trademarks, and many of the marks might not be needed either in the EU or in the UK. You could decide, okay, which trademarks will I maybe abandon? You would have to find a new representatives for the EU trademarks if right now these marks are represented by a UK practitioner, because at that time he would no longer be admitted to the EU IPO. Of course, many of the UK lawyers and trademark agents nowadays, they all of a sudden find that they have Irish ancestry, and they all apply for Irish bar registrations in order to still be able to represent. But it's not really likely that this is going to be accepted by the EU IPO. Obviously, you would also have to find representatives for this newly created UK portfolio, which all of a sudden and without doing anything you would own. And that basically means that if you keep all these trademarks, you have to double your budget, because now you have duplicated your trademark portfolio. Now let's come to the most likely scenario, the so-called hard Brexit. If the UK does not step back from the withdrawal, it will leave the European Union on March 30, 2019 without any agreement. And as I said, the probability is very high. There will be no transition period. From March 29 to March 30, there will be one step, and there's all of a sudden nothing. That basically means that all the EU laws and rules will no longer apply to the UK. It also means that that has nothing to do with IP. There will be no freedom of trade. Goods imported from the EU into the UK will be on customs duty, and vice versa. There will be no freedom of services, which basically means, for example, that a UK bank can no longer render financial services to customers outside the EU. They can no longer act before the European financial authorities. There will be no freedom of movement, which basically means that everybody who wants to travel to the UK needs a visa. A British person wanting to enter the EU needs a visa. If he wants to work in Germany or France or Belgium, he needs a work permit, and the same for the German who's working in the UK. All of a sudden, he needs a work permit. And one colleague of me said, for example, this is going to be nice in British football because most of the players there are EU citizens but not UK citizens. So all of a sudden, they will no longer be allowed to work. And if they want a work permit, their clubs must prove that there's no better player available or no comparable player available. So that's going to be nice. So EU law will no longer be applicable. What does that mean So this is then how it will look like. And you see this one issue there, the small Irish spot. This is one of the biggest issues, because there's going to be there must be a border between North Ireland and the Republic of Ireland. And you know that they have had a civil war going on for 300 years, which is just ended 20 years ago. And nobody knows what's going to happen if they reinvent this border as a hard border. It's going to be very interesting. So what about IP rights? I mentioned that with a soft Brexit, EU trademarks would automatically, without application, be transferred into or cloned into UK trademarks. This does not necessarily happen if we have a hard Brexit, because the problem is, without an agreement, the EU IPO will not send all the data to the UK IPO. They could send them, but they don't have to send them. And we don't know what's going to happen. Just yesterday, that was the last amendment I made to this presentation, I learned that there is a so-called technical note which was released by the British government on the hard Brexit. And they say they still want to do it. They still want to convert EU or clone EU trademarks into UK national trademarks, assigning them the same priority and filing date. If they are applications, they will continue to be applications also in the UK. They even say it's not going to cost money. I'm not sure how this is going to work. There's going to be one big issue, and that is the EU parts of international registrations. This is, of course, a common tool. The problem is, whereas the UK can decide on its own to simply say, okay, you own an EU trademark, we give you a UK trademark. They cannot decide on their own to give a UK part of an international registration to a trademark owner who's now owning a EU part of an international registration, simply because this is something that WIPO does and not the UK IPO. So for international registrations, nothing. We don't know what's going to happen. You might lose your trademark rights, or you might have to apply for a new UK trademark or UK part of an international registration, but of course then you have to pay for it, and you lose your application or priority date. So that's going to be a disadvantage anyway. So basically, it's very likely that you will need some kind of local representation in the UK. They could go for some years without, but sometimes you will simply have to have a local representative in the UK to represent your UK trademark portfolio. And obviously, UK practitioners from March 29 or March 30 onwards will no longer be allowed to represent EU trademarks before the EU IPO. So that's going to hit hard and very fast. What does this mean for trademark owners? Number one, right now, because you don't want to lose trademarks. And it can happen to you because we don't know what the UK is actually going to do. We do not know if they can clone these trademarks. So what I would do, and that is what I'm recommending to my clients, I tell them, look, you don't have to file all your EU trademarks and EU parts of international registrations as national trademarks right now in the UK. Many trademarks maybe you do not even need in the UK, and others are not so important, so then you can wait and see. Somehow there will be a solution. But your most important trademarks, the company core trademarks, you do not want to play games with them. You do not want to run the risk to lose them. So what I'm recommending is locate the most important trademarks and file now, before March 29, because on March 30, the IPO in the UK will really have problems because they simply don't know how to handle this. Nobody is prepared for that. Everybody in the UK thought that somehow we are going to have an agreement and then there's going to be a 2 years transition period. And now there will be no transition period. So if I were the director of the UK IPO, probably I would not really sleep well right now. As a representative of trademark owners, I would recommend my clients to locate the most important EU trademarks and EU parts of international registrations, file now, just as a backfall position. Maybe later there's a solution and then you just abandon them again. You need to find UK agents, because that's what you need for representation. But at the same time, you need to find new European representatives for your EU trademarks. And again, double your IP budget, because that's what you need. You will have a double portfolio. 49 working days to go from today. So we better start working. And that's it. Thanks a lot.
Thank you so much. And